Testing 1, 2, 3.
All right, council, I'm going to go ahead and call the 9:30 matter that is on the court's docket. We are on the record in cause number DC 22-14504, Damian Sanchez versus Shattuck Caldwell Builders and Developers LLC, a limited liability company. May I have the parties to announce on the record?
Michael, I'm sorry. Go ahead, Shelby.
Oh, good morning, Your Honor. My name is Shelby Bradley. I represent Shattuck Caldwell Builders.
Okay.
And this is Michael Lawrence. I represent defendant Rudy Mora and Rudy Mora Brick Masonry.
All right. I understand there's a motion for continuance that is set before the court today. Is that correct?
Yes, Your Honor.
All right. Who'd like to take the lead on presenting the court with the motion for continuance?
And I'm not seeing plaintiff's counsel here.
Yeah, this was her motion, and she set the hearing, so she's not here yet.
You know, it's an agreed motion. I mean, all parties have agreed. I think the problem is that trying to get client signatures. I tried filing something yesterday with my client's signature, but the court rejected it because it was just a signature page, and so I need to refile that with the signature page. But I don't know about Shattuck Caldwell's, client signature, but all parties agree. We've done several depositions, pretty much all the party depositions. We're now to the point where we're just needing more time with experts. And so that's why all parties had agreed if we could have a May trial setting. We've scheduled mediation for March, which is after the expert designation. So we'll have a better idea, as to what's going on with this case as far as liability issues and things like that. And so that's what we were just requesting a brief continuance, set for trial January 2nd, brief continuance to May 6th, I believe, was an available date for the court. And so I think the problem was getting the actual client signatures on the proposed order.
Okay, and you guys have mediation set currently, is that correct?
Yes, I believe it's March 4th is what I had on my calendar.
Okay. And is there a scheduling order in place as it relates to this case? If you know, if not, I have it up and I can check.
Yeah, there is a current scheduling order for the January 2nd trial setting, and then there is a proposed one that was filed yesterday by plaintiff's counsel with the May 6th setting that, as I said, all attorneys have signed, and at least I believe two of the individual parties have signed.
All right. I'm printing off a copy of the scheduling order that was uploaded on yesterday. Mrs. Kelso, you can announce on the record, I believe this is your case that we're hearing, the Damian Sanchez case.
Good morning, Your Honor. Rhiannon Kelso for the plaintiff, Damian Sanchez.
Good morning. Counsel for the defendant, Mr. Lawrence, was just updating the court as to where you all stand and what is left to do as it relates to get this case prepared for trial. Is there anything that you wish to add to that, Mrs. Kelso?
No, Your Honor. I certainly wasn't late to the hearing. I'm not sure why I was stuck in Zoom land, but I had been on there for a while, so sorry to miss the first few minutes. It's just a complicated case, and I think we're on track to meet the deadlines that are in our agreed scheduling order. I don't anticipate there being any issues with those deadlines. The purpose of me setting this hearing was simply because counsel agreed to this continuance in early September, and having to revise the scheduling order, the last one of which I revised on November 1st, I wasn't getting the agreement of defense counsel despite multiple follow-ups, so I set it for hearing, and here we are.
All right. I will grant the continuance. I've signed a copy of this scheduling order, and you all should receive electronically a new notice of trial setting, at least by the close of business today. Is there anything further?
No, Your Honor.
No, Your Honor.
Okay, that concludes our hearing. Thank you so much.
Thank you.
Thank you, Your
Thank
Honor.
you. Thank you.
Hi, Todd.
Hey, Scott, good morning.
Good morning.
All right, council, let me call your 9:45 matter that is on the docket. We're on the record in cause number DC 22-11651, Jason Lavender versus Pegasus Link Constructors LLC et al. May I have the parties to briefly announce on the record? Let me know your name and who you represent.
Good morning, Your Honor. I'm Todd Riff here on behalf of plaintiff Jason Lavender.
Your Honor, Scott Bradley. I represent defendant Pegasus Link Constructors.
Vernon Howerton for third-party defendant, Safety Cop.
All right, I understand this is a second agreed motion for continuance. Who'd like to take the lead on presenting it to the court?
Your Honor, I'll do so. I put it together. Again, this is Scott Bradley, counsel for Pegasus Link. Briefly, this lawsuit arises out of an accident that happened in December of 2021 at a construction site there on LBJ, I believe. And, excuse me, I take it back. It was actually Highway 67 was the particular area in question. A vehicle traveled into the construction zone where plaintiff Jason Lavender was working as an off-duty officer providing traffic control. This vehicle struck Mr. Lavender's vehicle, causing him injuries. At that time, Mr. Lavender was working the construction site for the benefit of Pegasus Link through his employer, Safety Cop. And so Mr. Lavender sued Pegasus Link, and up until August of this case, it was just plaintiff suing Pegasus. We obtained the court's approval to bring in Safety Cop as a third-party defendant in order for us to be able to get the benefits of Pegasus's contract with Safety Cop, which included insurance coverage, indemnity, defense, things like that. With the approval in August, we were able to get them served the following month, and as of October, Safety Cop came into the case. Now, in that time, plaintiff Lavender and Pegasus had been operating under a scheduling order, and a number of the deadlines to that point had passed or were coming up with such rapidity that Safety Cop really wasn't going to be able to either comply, or deadlines had passed and Safety Cop wasn't going to have an opportunity. For example, we'd also done discovery, plaintiff Jason Lavender's deposition. We did the deposition of 2 Pegasus Link employees, and Safety Cop wasn't a part of any of that discovery. We also had a late November mediation date that just simply wasn't tenable, given that, you know, there's a lot of moving parts now with a third-party defendant in the case, and it's my client Pegasus's position that what we need is a Safety Cop that is completely up to speed, comfortable with its knowledge of the facts of the case, and ready and willing to participate in a mediation to the extent that it is able. And so looking at sort of the global circumstances, the new party Safety Cop, the work that has been done, the work that remains to be done, the consensus among the parties was we would like to adjust our trial setting, which is currently in March of next year, move it to the late summer, early fall. I think we suggested September to the court. But that ballpark I know would be satisfactory to Pegasus in order to give the parties time to incorporate the new third party, maybe take a run at mediation sooner rather than later, and then still enable ourselves to be prepared for a trial setting on the merits if we need to do that.
All right. And was there a scheduling order that was submitted with this or no, counsel?
I believe we had a scheduling order that was submitted. I'm sorry. Do you mean with the second motion for continuance?
Second motion for continuance.
No, Your Honor. We had not come up with a specific scheduling order because naturally I think we wanted to see what the court thought of a September setting, if that was agreeable, and if so, then the 3 of us would be able to very quickly put together a scheduling order that tracks the court's typical dates and deadlines.
All right. Hold on one moment. I will grant the continuance. I cannot give you a date in September. What I will do is when I conclude my morning hearings, I will be working with Mrs. Alonso and will identify a date on the court's trial calendar to move you all to. I would ask that you all submit a scheduling order based off of that new trial date that you will receive from the court. And I want to make sure that any additional motions for continuance, hopefully there will not be one. Make sure that you all adhere to the local rules and include your client's signature on the motion for continuance that you submit to the court.
Yes, Your Honor. Thank you.
All right, is there anything further?
None for Pegasus, Your Honor.
None for the plaintiff either, Your Honor. Appreciate your time.
All right, Mr. Howerton?
None for Safety Cop other than to say good morning, Your Honor.
All right, okay, thanks so much. Have a good weekend.
Thank
Yes,
you.
sir.
You too.
Take care. Bye-bye. All right, council, I'm going to call the 10:45 matter. We're on the record in cause number DC 22-08816 Dorothy Branton et al. Versus Paragon Ancillary Services LLC et al. May I have the parties to briefly announce on the record? Let me know your name and who you represent.
Good morning, Your Honor. Brent Kugler for plaintiffs Dorothy Branton and Dennis Branton.
Good morning.
Good morning, Your Honor. Brandon Maxey, along with my partner Rob Rickman here for defendants Chabonneau and for Ethicus Grapevine LP.
All right, good morning.
Good morning.
Good morning, Your Honor. Mark Ratway for defendants PSN Affiliates Series LLC, and Ethicus Hospital DFW LLC.
All right. All right, this is set for a joint motion for continuance and entry of an amended scheduling order. Who would like to take the lead on presenting that to the court?
Your Honor, I'm happy to do that. And this is Brent
Okay.
Kugler for the plaintiffs. Your Honor, this case is over a year old at this point, but this is the first motion for continuance that's been filed, and it's a joint motion by all the parties. This case is a bit more complex than a two-party breach contract case. There's 13 defendants. There was one third-party defendant that's been non-suited. The plaintiffs have been diligent, and two defendants did not answer, and we moved for default judgment. The court entered a default judgment as a liability, and we just need to prove that up with damages, which we can do at trial or before if the court wants. But it's a 13 defendant case, Your Honor, and it involves a series of transactions that occurred after the plaintiffs sold their interest in a long-term care hospital. And the entity they sold it to, Paragon, signed a $4.5 million note and never made one payment under that note. And we have, through investigation, found out that the owners of Paragon, or the plaintiffs allege that the owners of Paragon transferred the assets of Paragon through a series of transactions, ultimately selling what was left of those interests in the hospital to what we've referred to as the PSN entities, PSN Affiliates LLC and PSN Affiliates WTT ETM series. So there's a number of transactions. Just with 13 defendants, there's been a lot of written discovery. And in August, when I broached the issue of starting to schedule depositions in this case, the conversation turned to, would it make more sense to allow the parties to mediate before they incur the cost of depositions? And there was agreement amongst all the lawyers to pursue that path. From the plaintiff's perspective, we suggested a mediator, got mediation dates. It's just been a matter of getting the mediation scheduled. And I'll let counsel speak to, what they've done about that. But that's still, I believe, the mutual goal, just because we think that the money spent in depositions may be better used trying to get this case settled with a good mediator. So we're asking the court to, given the complexity of the case and the significant expense of deposition discovery, to continue the case, allow mediation, and if not, the mediation doesn't occur, we'll get the depositions done and be ready for trial. We've asked for a September trial setting, and that was my response to a request to set it out even further than that. But obviously the court can set it whenever the court really thinks it should be ready to go to trial. And if that's before September, we don't have any objection with that.
All right, and I believe you had indicated, counsel, maybe somebody can update me as to efforts to get the matter mediated. Is there somebody responsible for taking the lead to try to find some mediators?
Well, Your Honor, this is Brent Kugler again. We suggested Mark Calhoun as a mediator, and the main reason I suggested him is because he has had some experience in hospital-related litigation. I think the parties are in agreement with Mr. Calhoun. We've offered some dates. We've gotten dates back from some of the defendants, not from other defendants, but no one's, I think, opposed to Mr. Calhoun. I will say this, that Mr. Deloney, who's Mr. Knutson's counsel, and he may not be on this hearing because he said he had to be in court somewhere else today. He's been very candid up front, saying his client, who I believe is having some issues on the criminal side of things, is very pressed for money. And I think the parties are agreeable to mediate without Mr. Knutson if he can't afford to mediate, or allow him to mediate without having, and he just doesn't have to pay the mediation fee, I guess.
All right, and it looks like you all have submitted an amended scheduling order. Is that correct? Looks like it was filed with the court maybe like on November 2nd or
That's
November 3rd. Is that correct?
That's correct, Your Honor.
All right, and all right, I will grant the continuance. I can't give you a trial setting as of right now. What's going to happen when I conclude my hearings this morning, I'll be working with my administrator to identify a date on the court's trial calendar. You will receive a notice of trial setting electronically, and that is how you will receive your new trial date. But I will grant the continuance you are seeking.
Okay, thank you, Your Honor. Do you need anything further from us?
Not at this time. I'll sign that scheduling order. And as again, as I mentioned, you guys will get a new notice of trial setting sent out to you all electronically. Okay.
Okay.
Thank you, Your Honor.
Thank
All
you,
right,
Your Honor.
that concludes our hearing. Thank you so much.
Thank you.
Thank you.
Bye-bye.